This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about why a criminal trial for insurance fraud and arson can be delayed even past the speedy trial requirements because of the delays caused by the COVID pandemic and by a waiver from the defendant. There is no right to trial if the defendant waives his right to speedy trial. On February 12, 2020, the state of Indiana charged Franklin Lee Boger with one count of level 2 felony arson resulting in serious bodily injury, 4 counts of level 4 felony arson, 1 count of level 6 felony arson, and 1 count of level 5 felony insurance fraud. Boger's trial was set for a date certain, continued with the agreement of Boger several times, and without his agreement several more times. He appealed in a case entitled Franklin Lee Boger v. State of Indiana, where the Court of Appeals of Indiana on December 5, 2024, was faced with his request for dismissal of charges because of the delay in trial. The state filed charges against Boger on February 12, 2020. On March 11, 2020, the trial court set Boger's trial for August 17, 2020, and then on August 11, 2020, the state moved to continue the trial date, citing congestion of the court calendar. However, Boger also moved to continue the trial date, and the court granted his request, noting that waiver of rights under Criminal Rule 4 and reset the matter for at least 3 more times. On March 3, 2021, Boger filed a speedy trial motion, which the court granted, designating the May 24, 2021 trial date as the speedy trial setting. Further continuances were granted because of the COVID pandemic and its restrictions set by the Indiana Supreme Court. On March 31, 2024, Boger filed a motion to certify the denial of his 5th motion for discharge under Criminal Rule 4C for interlocutory appeal, which the court granted and brought to the Court of Appeals. Boger claimed that the court erred by denying his 5th motion for discharge because he was not brought to trial within the 1-year time frame set out in Criminal Rule 4C. The delays challenged in the appeal were justified, however, on grounds of congestion of the trial court's calendar. Indiana Criminal Rule 4C generally implements the constitutional right of an accused to a speedy trial, but beginning on March 3, 2020, the Indiana Supreme Court entered a series of orders tolling the operation of Rule 4C due to the COVID-19 pandemic. Boger's calculations of delay attributable to the state of 462 days did not take into account the tolling orders. The trial court did not explicitly find an emergency. However, the court's reference to the Supreme Court's order is indicative of the court's reasoning and supported its conclusion that Boger's trial court could not be held before March 1 of 2021. Criminal Rule 4 places an affirmative duty on the state to bring defendant to trial within 1 year. A defendant with adequate proof may successfully challenge a declaration of court congestion on appeal, but Boger did not do so. The Court of Appeals concluded that Boger did not show that Criminal Rule 4C was violated, and therefore There was no clear error, and the order therefore must stand. Since Boger did not establish clear error in the trial court's decision to deny his fifth motion for discharge, and because the Court of Appeals declined to address his constitutional claims brought for the first time in his opening brief on interlocutory appeal, the trial court's judgment was affirmed. In my opinion, the charges Boger faced were very serious, and conviction could result in extensive jail sentence. Delay worked to his benefit, and he therefore waived his right to a speedy trial and to trial within a year in accordance with Indiana rules. The pandemic also resulted in delays, and after a review in detail of the delays, continuances, and agreements by both the state and Boger were found to be appropriate because the trial court did not commit any version indicating clear error. He still faces trial in the criminal courts and litigation with the insurer he attempted to defraud. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,950 blog postings. You can also subscribe to these videos. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.